Okay, well, it is 1 o'clock, and we'll go ahead and kind of get this underway. So just in case you haven't seen me around enough yet, my name is Richard Swan, and I am the Associate Director at the Center for Teaching and Learning. And we will be having a session today on copyright issues for teaching and learning. And some of this applies both to on-campus, but specifically for online teaching and learning. And we will have Peter Midgley and Cami present to us today. The idea here is we'll have about a half an hour for presentation. And then if you need to go do something else, you are free and excused to go do something else. But we will hang around for another 15 minutes or so, depending on how many questions you have, and have a question and answer session after the presentation. And with that, I would like to thank all of you for being here today and turn the time over to Peter and Cami.
Thanks so much, Richard. It's great to be with everybody. We're just going to go ahead and get started. As Richard mentioned, we have copyright essentials for remote teaching. Copyright law is can be a complex and sort of nuanced area of the law. We're trying hard to distill it down to just the information and make it very practical. As a way of background and context, copyright covers a wide variety of works, everywhere ranging from literature to music and architecture, including choreography even. Anyway, the point of this slide is just to illustrate that the vast majority of content that you might encounter online is very likely subject to copyright protection, so we need to consider what rights we need to be respecting. In United States law, there are 6 exclusive rights which are enjoyed by every copyright holder. There they are listed for you. Again, there are various contexts in which all of these rights are relevant to us, but for our purposes, for the purpose of remote teaching, we want to place particular emphasis on the right of reproduction, the right of public performance, and the right of public display. And so understanding these rights is critical before we can do any kind of meaningful copyright analysis. So the examples we're going to walk through are going to illustrate how these rights apply in the context of remote teaching. But again, we're going to be focused primarily on these 3 rights as we discuss various examples. And with that, I'm going to turn it over to Cami.
Perfect, thank you. So like Peter said, we just have a few examples here that we are hoping are relevant to you and help you understand considerations as you're developing course materials for the fall. So the first we're going to look at are teaching with audiovisual materials. We have this scenario here as a commercial music instructor. They want to incorporate video content into the course. The instructor found this video on YouTube that she thinks will be a great way to start the class discussion on legal issues related to a career in music. And so the instructor actually wants to navigate out to YouTube. So engaging in this behavior that we're doing right now. So I'm going to actually leave the PowerPoint and go online. And so this is the behavior that we're talking about right here. So we're going to just show you a little bit of this video here.
Law. You're having a hard time getting shows, recording, selling records? How about suing a major artist? If you came up with a melody or a beat or a lyric, you can sue anyone.
I get to sue all my favorite musicians.
Bruce Springsteen, Elton John, Radiohead. Come in and you go, hey man, I recorded this little tune, ba ba ba. I go, shut up. Ba ba ba, is that what you said? Mm-hmm. Ba ba ba. Go online, find a song. It's weird. Isn't that crazy? Lawsuit has begun. I don't even have to hear your melody for me to know that someone else stole it. They think you're stupid. I'm here to say that you might be stupid, but I'm smart. And I can represent you, the dum-dum. I'm like the lead singer. And in court, that's my stage.
I think Mark should win a Grammy.
Oh, come on.
For suing.
Listen to these clients.
Perfect. So that's the clip. As an instructor, I want to show at the beginning of my class. So the first question you should ask yourself here is which rights are implicated by that scenario we just looked at. So as Peter was talking about, these different rights, by navigating out to YouTube, there's no reproduction happening. Because this is an audiovisual work, there's no display happening. So all we need to worry about here is the public performance of this copyrighted work. And so our office has created some tools to help walk you through determining how you can use copyrighted materials. If you come to our office's website, copyright.byu.edu, and this home page, you'll see right down here is what we call the copyright decision trail. If you click on this link, it will take you to, let's see here. Here we go. Okay, so it'll take you to here, to this page. There's an informational video you can watch, but if you go to the decision trail, this is our decision trail tool. It should be pretty easy to use. You can just hit start. And so we're thinking through this public performance of the copyrighted work we just viewed. So we first ask ourselves, is the copyrighted work in the public domain? If you just hover over the yes and no buttons here, you'll get some basic idea of what is and is not in the public domain. But if you have more questions, you can always click on the question mark button, and it will take you to a page with more information, as well as some helpful videos that might provide a little bit more context for the question. In this case, because this YouTube video is not old, it was not published before 1925, it's not in the public domain. So I'm gonna go ahead and select no here. The next question is, do you have permission to use it? Again, you can toggle over these options, get some idea of what permission looks like. In this case, a YouTube video is not licensed under a Creative Commons license. It's not part of a database that the university subscribes to. So we're gonna go ahead and click no here as well. The next question is there an exemption that covers your use? So here, I'm actually gonna click on this question mark icon here, and the primary exemptions that are related to educational uses are the face-to-face teaching exemption. Because we're dealing with online and remote instruction today, that one is not relevant to us. There's also the library exemption here, but the one we're going to be concerned with right now is this Teach Act distance education exemption. So I'm actually going to click on this link. It will take you to the Copyright Office website. So the Teach Act is a provision in copyright law that allows for the performance or the display of copyrighted materials in distance education. And so you can get information on what the Teach Act is, scenarios of when the Teach Act may apply, when it does not apply here. There's other information on this site if you have additional questions or want additional information. What we're going to look at right now is the Teach Act flowchart. So because the decision trail tells us the Teach Act potentially covers our public performance, we're going to come through here. The first question, as you can see here, is, are you transmitting a performance or a display of a copyrighted work? So we're not dealing with reproduction, distribution, anything like that. We're just dealing with those two rights. And because we answered that this just deals with the public performance right, we know that we can answer yes to this first question because we're transmitting a public performance. So we get down to question 2, will the performance or display be given by means of a lawfully made copy? So we've navigated out to YouTube, that's the source, and it's published by, the video is published by the copyright holder. So we can answer yes to question number 2 and move on. Is the work produced or marketed primarily for use in online education? This video is from the TV series Portlandia. It's an entertainment series, and so it's not produced primarily for use in online education. So we'll go ahead and answer no to this question, which allows us to move on to question 4. We ask, is the performance or display made by or for an instructor and directly related to the teaching content of the class? So as the instructor, I've navigated out to YouTube. I am the one who's initiating that public performance, and the content of that performance is related to our class discussions. We can answer yes to number 4. And then question number 5 asks about putting technological measures in place that allow, that limit the ability for students to retain or further disseminate copies of the copyrighted work. If you are uploading content to your password protected LMS, you're using Learning Suite or Canvas, generally you can answer yes to this question. So then we come down to, once we've answered yes to question 5, we're in this world of, we know the Teach Act now covers our use. So now we look at what type of use is it. We know that what we're doing is performing a work. So we're in this section here. We look at the type of work. So this is an audio-visual work. So it's going to be in this second box down here. We're not dealing with a non-dramatic, literary, or musical work. If we were, the Teach Act would cover the work, the performance in its entirety. But because what we're dealing with is an audio-visual work, you look here and it says that the Teach Act authorizes reasonable and limited portions of the work. So under the law, basically that means as long as you are just providing what is necessary to your teaching objectives, that's generally what's considered reasonable and limited. So we know now that for this first example, we are covered by the Teach Act for that public performance, so we're good to go. And if we go back to now our PowerPoint presentation, we're going to take this same scenario and just tweak it a little bit. So now we have the same instructor who wants to provide the same video to her students, but this time she wants to just provide a link to the video in her syllabus and encourage her students to watch it throughout the semester. So we asked, does the instructor need to obtain permission? Again, if we think about these exclusive rights, this is a bit of a trick question because by providing a link, we're not reproducing, we're not publicly performing or publicly displaying the work. Generally, sharing links does not implicate any of the exclusive rights of the copyright holder. So we encourage you to share links whenever possible. As you can see here, a word of caution, avoid sharing links to sources that appear to be infringing or suspicious. So for example, if I, Cami Stevenson, on my personal YouTube channel, upload an entire Marvel movie, you can guess I don't have authorization to do that. The same thing if on my personal blog, I upload an entire history textbook, we encourage you not to link out to those sources. Those are also, when you link out to unauthorized sources, that's when you have an increased risk of broken links. So that gets us to our third kind of iteration of this example. So we have the same instructor who wants to avoid this problem of broken links. And so she wants to save a local copy of the video to her server and then upload it to her password protected LMS. So this time, I'm actually going to have a poll. You all should see this poll appear here. Go ahead and just vote on which of these exclusive rights you think are implicated by actually downloading a local copy and then uploading to your LMS. We'll give you just a few seconds here. Okay, we'll go ahead and stop here. So here's our results. A really good effort. Most of you, there is this reproduction happening. And then there's also this public, it's actually a public performance, not the public display, because it's an audiovisual work. So if we look here, we know that the public performance is covered by the Teach Act. We've already gone through that. Now we just need to think about this reproduction that's happening because we're saving a local copy to our hard drive. So if we go back out to our Teach Act website, so again, you can navigate to this through the Copyright Office website. And we come up here, as I mentioned, the Teach Act itself only covers the performance or the display. However, there's this companion provision in the law for ephemeral recordings that basically says if what you as the instructor are doing is making a reproduction of a digital work or in certain circumstances, an analog work, if what you're doing is making that reproduction in order to facilitate a Teach Act performance or display, then under certain circumstances, that reproduction is covered. So you can see here the criteria. If you make a reproduction, it has to be retained and solely used by BYU. No further copies can be made or distributed to your students or to anyone else. And the copy that you've made can only be used in order to facilitate that Teach Act protected performance. So again, if what you're doing is performing or displaying and you've already cleared that performance or display, this provision now says the reproduction that you make in order to facilitate that performance or display is covered. So we now know, if we go back to our presentation, that we have this protection for both the public performance as well as the reproduction. However, as you can see here, copyright law prohibits people from doing what we call circumventing technological protection measures. So when a copyright holder has work on an audio disc or a DVD, there are technological protection measures that are put in place on that media in order to protect the work from being replicated or distributed in unauthorized ways. And so when we rip content from a CD, a DVD, from YouTube, that is circumventing those technological protection measures. So that's prohibited by copyright law. So when you come to make a reproduction in order to do a performance or a display under the Teach Act, what we typically will recommend is that you use some sort of screen capture technology. So what we just did with our audio-visual clip here from YouTube, this is being recorded on Zoom. We've recorded that performance, so the reproduction has happened. So that reproduction is okay under the ephemeral recordings provision in order to make our Teach Act presentation of that audiovisual clip. So that's what we mean here by recording of playback from licensed players. We recommend that you use some sort of technology, screen capture technology like Zoom, in order to be able to get those, make those reproductions. So we're gonna, and just one word of caution here. Oftentimes people will come to us and they'll say, but everyone is doing this. It's everywhere. Everyone's ripping content. Everyone's uploading stuff they don't own. Just because content and websites exist doesn't mean that they're legal. So here's this headline that just notes, this major organization that was ripping audio content was pulled down by both YouTube and is being sued by labels. So we just want to make sure that as we're getting content for students, that we're doing it in a way that's kosher and that we're going to, be okay. And we found that screen capture technology is an easy way to do that. So next, we're going to go on to teaching with images. So we have here another example. This is very similar to that first example we looked at with audiovisual content. So an instructor actually wants to navigate out to a website to show a cartoon to their class. Again, all we'd be implicating here, instead of the public performance right, like we were implicating with the audiovisual work, all we're dealing with here is the public display. And so if we go back to our Teach Act flowchart, it will tell us that the Teach Act will cover a display of any work in an amount comparable to what is displayed in a live classroom setting. So again, if I'm navigating out to a website and showing an image as part of my lecture, that display is covered in an amount that's comparable to what is made in a face-to-face classroom setting. But then if we switch up this hypothetical a little bit, so now we have this same professor wants to include the PowerPoint or include this image as part of their PowerPoint presentation, as part of their lecture. And they want to make that PowerPoint file available as a standalone file for students to go back and refer to throughout the semester. So we again ask which of these rights are implicated. The display right we know is covered by the Teach Act for an amount comparable to a face-to-face class. So for the lecture display, the Teach Act covers that display. And we know from our previous example, the ephemeral recordings provision, that in order to make that reproduction in the PowerPoint lecture, we can make that reproduction under the 112F ephemeral recordings allowance. However, this has a bit of a wrinkle in that the instructor now wants to also upload the PowerPoint as a standalone file. And now we're in this situation where the Teach Act will cover the display of a work in an amount comparable to what's in a live face-to-face class. By providing the PowerPoint as a standalone file, we now no longer satisfy the Teach Act display, right? Because the image is available for much longer than what would be available in a face-to-face class, as well as providing the standalone PowerPoint file. When we provide the video through our LMS, password corrected LMS, there are technological measures in place that prevent downstream retention and downstream distribution by students. That is not the same as providing a standalone PowerPoint file. Students can right click and save as, download the images. And so the Teach Act does not qualify, does not protect the standalone PowerPoint file. So inclusion in the lecture is still covered by the Teach Act and the ephemeral recordings companion provision for both the display and the reproduction. But that standalone PowerPoint file is not covered by the Teach Act. And so when we go back, if we'd gone back to our decision trail, the next question on that decision trail after is there an exemption asks us, is what you're doing a fair use? And Peter will actually get into the discussion of fair use and how you determine whether or not something's fair use. And so in this case, if you were providing the standalone PowerPoint file, you'd want to look at whether or not that reproduction and display would be considered a fair use. And so Peter will go through fair use here in just a few minutes. And then finally, what I want to just show you is we often get questions from faculty as they're wanting to build their courses and incorporate image content, how they can go about finding images that are okay to use. So in this case, we have this image of a flamingo. The professor wants to build a kind of a getting to know you PowerPoint presentation for the first day. And so when we go back to our decision trail, again, we know that this is not a public domain image. We don't have permission to use it. What we're doing here is making both a reproduction as well as a public display because we're saving that image in our PowerPoint presentation. So we know it's not the public domain. We know we don't have, we get to this question about permission. And as Peter mentioned a few minutes ago, briefly, there's this idea of Creative Commons. Creative Commons is an organization that has created a suite of licenses that creators, photographers, artists can actually proactively license their content and make it available to the public. So if I'm a photographer, if I take my iPhone out this weekend on a hike and take some pictures, I can actually go to Creative Commons' website and upload those pictures for anyone to use and assign it a license that I say, okay, as long as you comply with these terms, you don't need to request permission from me. So what you'll see on Creative Commons' website are these different type of licenses here. Anything that is CC is just Creative Commons. The BY simply means that license requires you to give attribution to the original creator. The SA means share alike. It means if you make any modifications to that image, you need to note those modifications as part of your attribution and just share your image your modified image under the same license. NC simply means non-commercial. You cannot use that image in a commercial way. You cannot sell it. It builds upon itself here, NCSA. And finally, this license here, the ND, means no derivatives. So you cannot make any modifications to that image. You cannot crop it or color correct it or anything. So these are the different licenses you'll see through Creative Commons. Like I mentioned, anything with the BY requirement means that there is a requirement for attribution, and you'll see all 6 of these have that requirement. Down here in the bottom left-hand corner, you can see the attribution, what Creative Commons calls the ideal attribution. It basically, if you remember tassel, title, author, source, and link. So here I just said photo, which is hyperlinked to the direct source URL for this image. By, here's the photographer's name, hyperlinked to their page on Flickr. And then the license, CC BY 2.0, and that is hyperlinked to the license terms on Creative Commons' website. And so we have a short video our office has created to basically show you how you can use Google image search in order to find these types of Creative Commons licensed images. So we'll go ahead and show that here.
Today we want to show you a little known but invaluable tool if you're looking for royalty-free images for use in a creative project, and it's all built right into Google. Say I'm looking for a great picture of a shark for a new brochure I'm working on called "What's a Card Shark? Sharks Can't Play Cards and Other Fun Facts About Sharks." Working title. All I have to do is go to Google, search shark, then hit the Images tab. Over here, there's a little button called Tools. Click on that, and from the new filtering menu, select Usage Rights. Select the usage rights you need for your project. My brochure needs me to modify this photo slightly, so I'll choose the rights labeled Reuse with Modification. Then Google will sort the photos for you. It's always wise to go to the site that hosts the photo to double check that you can use it the way you want, but this search tool will help you find photos that have been specifically designated for reuse in creative projects. So there you go. It's just a quick tool built into Google, and it should save you a ton of time.
So there we go. Hopefully that's just a quick little tip for you guys as you're looking to create content, and that video is available on our BYU Copyright YouTube channel if you want to go back and refer to it. And now Peter will go ahead and cover supplemental readings.
Okay, thanks, Cami. Yeah, so we have, obviously, in addition to all of the media that you might want to use in your lectures, we get lots of questions about distributing articles or chapters from books, you know, that are separate from the required textbook for a course, for example. So one service that we want to be sure that everyone on this call is aware of is the Course Reserve service offered by the BYU Library. In this particular example, we have an economics professor who wants to distribute this article, an article from this journal here that's 26 pages long. There are 30 students in the course, and they want to make it available digitally through the Course Reserve system. Want to just quickly demonstrate how they would go about doing that. You go to the library's main site, and you click on this Course Reserve link here. Don't have time to go through a detailed demo, but there's a tutorial here if you've never used this service before. But what's going to happen is when you send this article in to the Course Reserve system, you'll come to a page. Oh, sorry. Which of the exclusive rights is implicated here? As we're going to see, you'll select the article. The library staff will go through and determine whether or not there's some existing subscription. And in this particular case, the library subscribes to the EBSCO database, which includes this journal. So from there, they will make the link to the appropriate library resource available to all your students directly through Learning Suite. And so if we were going through our decision trail, we would realize that all we're doing in this case is sharing a link. And as we indicated earlier, sharing of links is a great way to avoid any copyright concerns. And the nice thing for you as faculty members is you don't have to worry about whether or not a particular article is covered or how to generate that link. If you know how to do so, you're certainly welcome to, but you can just have the library staff do that for you through the course reserve system. Okay, that same system covers a wide variety of formats of works. As you can see here, the library can go out and secure unlimited ebooks in some cases, music, videos. So it's not just limited to articles that you want to distribute. Anytime you have a question about a particular piece of content that you want to distribute, the course reserve system is a great service for you. Another example would be a course pack. So if you really want your students to have a hard copy of, you know, here's 11 pages in this example that an education instructor wants to offer up from this book. It's only 11 pages. The book costs, you know, $33 there basically. And so the professor doesn't want all the students to have to go out and spend $33 to read these 11 pages and is wondering, can I just insert those 11 pages into a course packet and have my students buy it from the store? So in this case, because we want to make a physical copy, what we're dealing with is the reproduction right here. That's not a performance, it's not a display, but it is a reproduction. And again, as with Course Reserve, the BYU store has an interface where you can go and submit these materials. The store will check against all the licenses that are in place, and it will also do a fair use analysis to determine whether or not a license is required. In this particular case, because it's only 11 pages, going through the fair use analysis would indicate that a license is not required. This is a small enough part that we don't even need to pay for a license here. Our final example is one where you, the faculty member, might decide, I don't want to go through the library staff. I don't want to go through the store and have my students purchase it. I have the book sitting here on my shelf. I'm going to go grab it. I'm going to scan a couple chapters and upload those chapters straight to Learning Suite so my students can just access it directly. And that's fine to do that. You just need to go through your own copyright analysis and ask, okay, can I do that? So the first question again that you would ask is, which of these exclusive rights are being implicated? In this case, because you're scanning and making a copy that's then being uploaded, you're dealing with the reproduction right. And so again, we'd encourage you to go to our decision trail right here. And as Cami alluded to, you would go through those first 4 questions. I'm not going to rehearse them all again here. And you'd land at this question about whether it qualifies as fair use. Now, fair use is a tricky legal doctrine. It's notoriously nuanced and fact specific. And so it's very, very hard to say as a general rule, oh, as long as you're only using a small amount, then you're always going to be okay. Every case has to be analyzed on its own, and you have to look at all 4 of these factors. We also have this very handy tool, which we're really excited about because we developed this in collaboration with Professor Clark Acey at the law school. So what Professor Acey did was review over 400 reported fair use cases and analyze each one of them by answering a bunch of questions about each case. We then took that group of cases and ran it through some machine learning so that you can go through and ask these questions, which I'm going to do here in just a second, and then you're going to get a prediction as to how a court would rule based on how your situation compares to all these hundreds of cases that we've analyzed previously. So the first thing you can do is fill out this form. This is optional, but if you want to fill this out at the end, you can get a time-stamped copy, which is helpful for us to demonstrate that we had a good faith reason for thinking that our use was fair. The classroom thing I'm going to skip for the time being. So the first factor asks about the purpose and character of the use. Is our use commercial? No. We just want to take a couple chapters from a book and distribute it to students for teaching purposes. That's not a parody. So we're not going to say that. It's for teaching purposes. I would check this box. I'm not doing any bad faith. is my use transformative? The word transformative is a very important word in fair use jurisprudence. And basically what it means is, are you using the work for its original purpose? In this particular case, the book that we have is, let's see if I can get back there. Yeah, so this is a book that was meant for use in the classroom, and we're using it pretty much for its exact purpose. So going back to our fair use checklist, we'd say, no, we're not using this in a transformative way. The nature of the copyrighted work, in this case, we have a couple questions to help you make the determination. This is not a highly creative work. It is published, which means that this factor favors fair use. The amount and substantiality of the portion used. We're using 37 pages. That's a large amount. So we'd say, yes, we're using a large amount. It's not the heart of the work, but overall, 37 pages is a lot. And so we would say, yes, this factor, or excuse me, no, this factor does not favor fair use. And finally, we're asking about the impact on the market. Now, again, this is a 619-page book. It sells for $146. You could argue 37 pages is not going to be a good substitute for buying a whole 619-page book. But in this case, the work is under commercial exploitation, and specifically, a lot of publishers license out to universities like us for this exact kind of use. And so our use would act as a substitute for that licensing market. We are able to locate the copyright holder, but we will give attribution. On balance, we're going to say that no, this factor does not favor fair use. We submit our answers, and the tool tells us, no, this is likely not fair use. Like I said before, you can download a PDF for your own personal records just to keep a track. If you do conclude that it's fair use, or if the tool helps you realize that, you can keep a copy for your records, which helps us. You know, heaven forbid if in a few months or years, the publisher finds out what you've done and sues you or BYU, it's nice for us to have a record that, no, we took a look at this back at the time, and we thought it was fair use after carefully considering all the factors. So that's the reason you do that. Let's see, I think these are just slides that basically cover, one way to kind of help you remember those factors. Here's a fun little acronym for you, PAIN. Not that fair use is a pain. We like fair use, but it's just a helpful way to remember those 4 factors, which have to be weighed and balanced in every fair use decision. Okay, so that's Copyright Essentials in a nutshell. We are, as mentioned earlier, we're more than happy to linger for any specific questions that you have in the context of your course. And we open it up now for questions.
And if you would like to put those questions in the chat, we can take a look at those there as well too.
I've got a question.
Oh yeah, go ahead.
Go ahead.
So if you were to mimic the classroom, so you using the example of that cartoon, and you're showing it at the beginning of your PowerPoint in a classroom, that's the only setting, then that is okay by the Teach Act. What happens if you do a recording of your Zoom session?
That would still, because what you're doing is still making that public performance, and the reproduction, because the performance is covered under the Teach Act, then that ephemeral recordings provision will allow the reproduction in order to make that performance. You're still okay as part of that recorded lecture.
So recorded Zoom session is okay, but PowerPoint file is not okay.
Yeah, because if you think about when you're displaying it as part of your lecture, it's still being displayed in an amount that would be about the same as a live face-to-face setting. But as soon as it's uploaded as a separate file as a PowerPoint, then students can access that in a much longer duration than they would be able to in a live face-to-face setting. So that's why the Teach Act would not cover it.
Okay, thank you.
And we're, I guess it probably goes without saying that we're assuming that your recorded lecture is not going to be posted to YouTube publicly or anything like that, that it will be, your recorded lecture will be available through Learning Suite or Canvas, or some password protected LMS. And that's the only place that students get to get access to it. Yeah.
Okay.
So I mean, it's an important point to note that a determined student or anybody else who is bent on the idea of getting access to materials that you're sharing, they will find a way to do that. I mean, there are mechanisms in place, And so what the law requires of us as an institution is not that we run around policing every single student in their dorm room who might be, I mean, who knows what they're doing, right? That's not our obligation. We just have to take reasonable steps to prevent sort of obvious examples. So if what we've done is make it so it's not easy to just right click, save as, download, then that's sufficient for our purposes. That's the position our office has taken.
And Peter, did you see this question in the chat? When in doubt, should we contact our subject librarian or the copyright office? If you have questions, copyright questions, I think our office is very happy to answer those for you. Outside copyright.
Yeah, your subject librarian is also a terrific resource. If it's a question of should the should the library go out and secure some additional materials, so should it add to its collection? I mean, that's obviously a question that's better directed to your subject librarian. And sometimes there are specific licensing terms around the way that particular content has been licensed by the library that are better handled by your subject librarian. But we're here as a resource. If you have any copyright questions, if you've got a really sticky fair use problem or something like that, I mean, this is what we do for a living. We live and breathe in this space, so we're happy to help you walk through a particular challenge, or if we need to go out, we can go out and contact the publisher and secure a license. I mean, we do that routinely, so we're happy to help wherever we can.
So Peter and Cammie, correct me if I'm wrong, but back to that previous question, once you put the PowerPoint file up there with that cartoon image loaded, then that cartoon suddenly now becomes copyable and then distributable by students. Would that be fair to say?
Yes.
Yeah, so that's why the Teach Act would not apply, is because not only is the display longer than a classroom session, but you've lost those technological measures that limit that downstream retention and distribution. Yep.
Yeah. So, any other questions? Our goal here is to help, again, like I said at the beginning, copyright can be a really sort of nuanced area of the law. And so we hope that through this session, you feel like you're empowered to make informed copyright decisions. If you can just, you can do a lot of the things that you want to do, and you just have to do it in the right way, is, I guess, the bottom line. So, things that, something that's frustrating for a lot of folks is they feel like, if I'm just trying to get to the same end goal, shouldn't I be able to, choose any path that will get me to the same ultimate result? But what we find in copyright law is it often makes a difference, the particular mechanism that you used to get there. If you want a fun example of that, you can just look at the recent litigation involving a local company, VidAngel. Some of you are probably familiar with VidAngel, who was offering a filtering service for streaming movies, and Disney and others were not happy with the way that they went about trying to offer that service, whereas some of their competitors, ClearPlay in particular, was successful because it employed just slightly different technological means for getting to the same end result. So these subtle differences can make a big difference in the copyright often. Okay, well, I don't know, Richard. I'm certainly happy to answer any other questions.
And if you have them later, that contact information, Peter, I don't know if you want to put that slide back up. I have that email address there. Feel free to reach out, phone number. We're happy to answer questions as they come up as you're, finalizing courses for the fall. So
we try not to be hard to find, so people's faces always light up when they see the Friendly Neighborhood Copyright Licensing Office coming down the hall. So always glad to help. Okay, thanks everybody.
Okay, well, thank you, Peter and Cammie, and thank all of you for coming and participating today. And we will see you at the next seminar, hopefully, and good luck with classes in the fall. We'll see you later.
Take care. See ya.
Bye-bye.